Okay, good morning, members and friends of our Family Business Learning community. I'm Sally Durstein, and I lead our team here at the Family Business Center. And I'm really glad you chose to join us this morning for our topic. We're going to be learning about, here comes the PRO Act, implications for family businesses. We've had lots of educational programs this month. Last Thursday, some of you joined us when we focused on the shareholder mountain with Tara Bond and Nellie DePietro. And next Wednesday, we hope you join us when Steve and Andrew will share a little bit about what it might look like to pursue a business acquisition and what you want to consider as part of your growth strategy. And on May 27, we'll be learning about the board mountain. We'll talk a little bit with Dave Griffith and with Julia Klein. So I'd like to begin by really thanking our EDU sponsors for their help and their support, also as they're helping with your businesses. I know I don't have them up here, but I'm going to name each of them. Fox Rothschild, and we have with us Bob Nagel, who's going to be presenting, and Kreischer Miller, and Proxys, RKL, and Hamburg Rubin, Mullen Maxwell, and Lupin. Well, our theme this year is all around creating cultures of accountability. We're learning how to do that on all the different mountains. And today is one of our best practice events. And so, Bob, we're really pleased that you're joining us to talk about this topic. I want everyone to know that you can ask questions. You probably will have questions. Feel free to put that in the Q&A. It's probably at the bottom of your screen. And we may hold them till the end. And just a word about Bob. Bob is a partner with Fox Rothschild, and he is an expert in labor and employment law and probably lots of other things. But today we are eager to hear him present on this topic. So Bob, I'm going to turn it over to you. And also, folks, just know that you can access this later through your member portal if you want to look at it or share it with others. So Bob, take it away.
Thanks, Sally, and good morning, everybody. Are those slides showing up on the screen, Sally?
Yes.
Great.
Yes.
Okay. So as Sally mentioned, the topic today is a piece of legislation sort of catchily and misleadingly named the PRO Act. That stands for the Protecting the Right to Organize. That is currently sitting in the United States Senate, having already passed the U.S. House of Representatives. If this bill were to take effect, if this bill were to pass, and President Biden has indicated he would sign it, it would literally turn upside down the present sort of framework and foundation for labor management relations in the private sector in the United States. And I've looked at the membership list for the Family Business Center, and I don't think anybody would be exempt from the provisions of the PRO Act were it to pass. So let's see. Oh, do I do that over here? Okay. So a little bit of background. The PRO Act is being offered as a substantial rewrite of what is currently the federal law in place, known as the National Labor Relations Act. Now, people remember their high school civics classes or American government classes might remember that the National Labor Relations Act was a key part of FDR's New Deal legislation that was intended to try to level the playing field between capital and labor at a time when, although everybody in the country was really suffering, the Roaring '20s were sort of viewed as a time when businesses were growing very large and prosperous. A little earlier than that, you had the trusts, the Vanderbilts, the Carnegies, the JP Morgans. And there was a sense that the little guy, the forgotten man, so to speak, wasn't really getting a fair shake and did not have adequate power or leverage to really represent himself or avoid being exploited by his or her employer. Back then, it was mostly his. So in 1934, a Democratic Congress passed and President Roosevelt signed the National Labor Relations Act. And ever since that time, that federal law has been sort of the backbone of the legal construct for labor management relations for all private sector employers in the United States. Unlike the FMLA and some of those other laws we talk about, there's no employee threshold. If you have two, I guess there's a small one. If you have two, employees or more and engage in any more than like, a couple dollars worth of interstate commerce, your business is going to be covered by the National Labor Relations Act. The National Labor Relations Act is administered by the National Labor Relations Board. The board is a sort of it's an executive branch agency. It's a little more independent from the executive branch than, say, the Department of Energy or the Department of Homeland Security, in that the board members, once appointed, do not serve at the pleasure of the president, unlike, say, a cabinet secretary. They get appointed to 5-year terms. And that results in, and I'm going to get to that in a minute, some staggered terms where, even into a Democratic administration, you still have a Republican majority board, which is what we have right now. The big board in DC kind of sits at the top of this whole thing. The general counsel of the labor board is a very important position because he, and it's currently a he, prosecutes alleged violations of the National Labor Relations Act. They decide when to issue a complaint in a given case and bring the full might of the federal government against the wayward employer or union, as the case may be, for violating the act. And then the NLRB itself, by and through its regional offices, which are scattered throughout the United States, also conducts union elections when the union has petitioned for an election and has demonstrated sufficient interest among the employees to have a union election. So change has already arrived and more is coming. If you go to the bottom bullet there, on January 20, President Biden hadn't been in office for 5 hours yet. And after demanding the resignation of Peter Robb, who was the general counsel appointed by President Trump 3 years prior, he fired him. President Biden fired General Counsel Robb because he refused to resign. And the next day he fired his deputy. That was essentially a coup d'etat at the board to remove what the incoming administration viewed as sort of recalcitrant, too business-friendly, insufficiently sympathetic to workers' rights and union rights, which are not the same thing, by the way. And they installed an NLRB lifer from Chicago named Peter Sung-Ur, who is currently the general counsel. And my view, and I am going to editorialize a little bit here, but my views are my own only and not mine of the firm. They're a view of somebody who's represented management exclusively in labor relations law for 24 years. Peter Sung-Ur, the interim GC, has taken actions that are designed to tip the playing field back in favor of unions at the expense of management. There's more changes coming. Currently, there are 3 Republican members on the board with 1 Democratic member, Lauren McFerrin, who's also the chair. She's a holdover from the Obama administration. She's been in there for at least 2 terms. She is going to be reinforced with two Democratic appointees over the next several months when the Republican members' terms expire. They're going to be replaced with Democrats. And then for the rest of this administration, which may be 3.5 more years, it may be 7.5 more years, there will be a Democrat majority on the board. And you can expect, this is like as the safest prediction one could make, you can expect that the pendulum at the labor board will shift back sharply away from management in terms of various management-friendly decisions that the Trump labor board implemented over the years, and back towards organized labor principally, and I would say secondarily in favor of individual employee rights as well. And you'll hear me say time and again that the interests of individual workers and the interest of unions are not the same thing necessarily. They are not coextensive. And frankly, I would suggest that if you're a union-free employer, and I don't know for sure, but I think the folks that are on the call today by and large, are union-free, are proud of their union-free status and want to remain union-free, I suggest that it is integral in maintaining your union-free status to understanding that not wanting to be unionized is not the same as being anti-employee or anti-worker. To the contrary, being pro-employee, pro-worker, treating your employees right, and never giving them a reason to think that they might be better served with union representation is the tried and true way to keep the union away. President Biden's declared agenda, he campaigned on the trail. He's going to be the strongest labor president you ever had. Just last week, kind of a splashy press conference rolling out an executive order where I think literally, the entire cabinet, the head of every cabinet agency is participating in a task force that's chaired by Vice President Harris that is designed to sort of examine all aspects of federal contracting and the federal government's interactions with the private sector economy, and trying to infuse organized labor, bolster unionizing efforts, make it easier for workers to unionize, and generally try to push the ball forward for organized labor. Now, a cynic might note a committee with 27 people isn't likely to get a whole lot done. Frankly, that's my hope. But thematically, the president is trying to sort of put down a marker that, hey, organized labor really helped me out in the campaign, and I'm going to repay that debt. And I really want to, show my support for organized labor. And President Biden's been a labor guy his whole career. I don't know that maybe his first job out of law school, he worked in the private sector. Since then, he's been a government lifer. So he's never really worked in the private sector. We all know he's never had to make a payroll. But he's always sort of identified himself as a union guy, like Lunch Bucket Joe from Scranton. He grew up with union guys. So I take him at his word when he says he wants to be the strongest labor president we've ever had. But as president, his power, although extensive, is still somewhat limited. And as we all remember, again, from high school civics or American government, Congress shall make the law. Congress has the power to pass laws and amend laws. And the PRO Act is designed to do that. And the overriding purpose of that is to make it easier for unions to organize non-union workplaces, strengthen their hand in collective bargaining, and increase penalties for employers who violate the National Labor Relations Act. So before we sort of get into like what the PRO Act would do or how it would change the law, I've given this talk 3 or 4 times now over the last month, and people, I think, have found it worthwhile for me to sort of provide a starting point to ensure that you have an understanding of like what the law is right now, right? You kind of don't know, where you're going unless you know where you are, right? So I don't want to just talk about, oh my God, it would make secondary boycotts legal if you don't know what a secondary boycott is and understand that right now that's illegal. So bear with me for 10 minutes or so while I kind of give you a summary or a primer of what the National Labor Relations Act currently provides as it pertains to private sector employers. First and foremost, said at the outset, it applies to virtually all private sector employers, regardless of your size, whether you're union or not, okay? And it's a fallacy among some unsophisticated companies who are non-union to think they don't need to worry about the National Labor Relations Act because they're non-union. Not so. Section 7 of the Labor Act provides that employees may support, form, or join a labor organization, okay, I get that, or engage in other concerted activity for mutual aid or protection. What's that? That sounds kind of vague, ambiguous. How big is that bucket? Or they may refrain from doing so, which union-free employers tend to like the part about refraining from doing so. So the key concept there in the middle, the engage in other concerted activity for mutual aid or protection, the shorthand for that is protected concerted activity, or PCA. And PCA includes a vast range of employee activity pertaining to their own terms and conditions of employment or the terms and conditions of employment of their coworkers. And most fundamentally, it sort of codifies employees' rights to talk about them. with each other, with the general public, with your customers, with your boards of directors, online, in the street, in the employee break room. You know, employee communication really is at the heart of you know, a lot of what we're talking about when we're talking about protected concerted activity. And let's be honest here, you know, the Congress and the Labor Board over the decades have realized that, you know, employees aren't going to be able to exercise their rights very effectively. They're not really going to be able to support, form, or join a labor organization if they can't talk to one another. If they can't talk to one another about their gripes and grievances, you know, they're not going to know maybe that there's, you know, other like-minded folks and you know, who want to band together with them. So for that reason, and this has always been vexing, it still vexes me. I understand it's a law, I just don't like it. Employees are allowed to criticize and disparage supervisors by name. They can criticize and disparage managers by name. They can do it online. Until last year, they could do it using the most extreme type of profanity. FF that mother effing F and his whole family. The NLRB said that was legally protected activity about 5 years ago. The Trump board kind of modestly pulled that back in a decision called General Motors, I think in 2019 or 2020. You know, organized labor, I really don't think many individual employees were that upset about that. Organized labor said, that's an assault on workers' rights. You're going to take us back to the 30s. Any marginal little restoration of sanity, from my standpoint, in the labor relations legal framework is usually attacked by the AFL-CIO as taking us back to the 1930s. So you need to understand that right now, your employees have various rights, actually a wide swath of rights under Section 7 of the National Labor Relations Act. Ergo, the Act prohibits employers from engaging in certain unfair labor practices. The sort of like hallmark catch-all baseline unfair labor practice, Section 8A1. Employers may not restrain or coerce employees in the exercise of their Section 7 rights. Also, employers may not discriminate against employees based on their support for a union, nor may an 8A5 only pertains to unionized employers. 8A5 said is an unfair labor practice for an employer to fail or refuse to bargain in good faith with a union certified as a representative of its employees. So if you have the misfortune of losing a union election and a union being selected as the bargaining representative of your employees, you as the owner cannot just ignore them and pretend that they're not there. You have a legal obligation to talk to them and bargain with them in good faith. And I'm going to talk about that in a minute. I do want to give one example of Section 8A1 and how that can be brought to bear in circumstances where you might not necessarily think it would be. So I currently represent a client, a building services provider in the New York City metropolitan area. They're about the largest non-union building services contractor up there. And for that reason, the Service Employees Union is all over them. They have mounted a full-on organizing blitz that's been going on for over 18 months now. They've organized a number of work sites. My client does primarily residential, but some commercial. That's the janitorial work, the concierge work at those high-end, you know, condos in Jersey City and Hoboken and elsewhere in the Gold Coast, and also in Manhattan proper. So we provide the concierges, the porters, the janitors, and the maintenance people at these buildings, and also security, but that's a separate line. So there is a very expensive high-rise in Manhattan. I don't know the neighborhood, but we provide porter service there and concierge service there. Now, the concierges are like doormen, right? What they used to call doormen. They work the front desk. They interact with the guests. We had an employee there who was violating rules. I'm not even going to get into what they were. They were a little bit ticky-tack. This is a non-union site. He was disciplined for violating one of those rules. He was also called out by a dog walker of a resident. This is the type of building where the residents hire dog walkers. And the dog walker accused him of making sexually charged remarks towards him and kind of creeping her out. Per policy, we suspended him for while we investigated that. We took a statement from the dog walker, we took a statement from another witness, and we concluded that while what he said was sort of inappropriate, it probably didn't rise to the level of sexual harassment. So we gave him a warning for that. And then per policy, though, we did not retroactively pay him for the 3 days he was out. We only do that if you're totally exonerated, right? We found like, okay, not like felony, harassment here, just a misdemeanor, inappropriate communication, keep it, cordial, just the basics. Don't be talking about how she looks great in that sweater and is she losing weight and, she should get her hair dyed a certain color. So he's unhappy that we don't rescind the suspension. The client is unhappy that we didn't take him out of the building, right? We're trying to walk a line here between not overreacting to what was sort of a minor transgression. He's unhappy because we didn't pay him for the time. And he contends that the warning for the other thing was trumped up and we only did it because he's a union supporter. He starts badgering residents about, can you believe my employer suspended me for, making a nice compliment to a woman and now they won't repay me and they're persecuting me and they're harassing me. So what do you think the residents of this, multi-million-dollar condominium do? They called the property manager and said, Bob, I'll just use my name. Bob is really like being a pain. Like, can we do something about him? So the client calls my client and says, Bob's got to go. He's wearing us out, right? Well, what's he doing? He's complaining to employees. He's complaining to residents and our board members about this suspension and this other thing. Like he thought if they brought, supported the union, they'd get more money. The client says he's got to go. So what do you think my client does? No, we're looking at it. We think he's got a legal right. There's something called the National Labor Relations Act, gives him the right to criticize and disparage us and talk to people. And I went to this webinar, this guy Nagel said it's like a really broad swath. Of course they didn't do that. They said, okay, we'll find another home for him. So we did. And what do you think happened? We got an unfair labor practice charge for the first warning, which they said that's not the real reason you disciplined him. You would not have disciplined him for that. We think that's a pretext to get him for his union support. And okay, yeah, maybe we get it that you had the right to give him a warning and not pay him for the time off while you were investigating the so-called harassment incident. But then when you transferred him away at the request of the client, that's an unfair labor practice too. And the fact that the client made me do it in the eyes of the labor board sounds like I was only following orders from another era. And guess what else happened? The union filed an unfair labor practice charge against our client because they're aware that the client had told us to take him away. So now the client is pissed at us. When we were only asking that, we only did what they asked us to do in terms of taking the guy away. It's a total mess. And any reasonable person without experience with this part of the law would be like, are you kidding? Like, how can that even be possible? Not only is that possible, right now, our worst day is, okay, you should put him back in that building, which is going to be a problem and which we're never going to do, by the way. And to the extent that he's making less at the other building you transferred him to, you should gross him up for what he was making, like $16 an hour at this building. We sent him to a building where he was making $14 an hour. Okay, $2 an hour for 10 weeks. That's not big money. That's what the law is today. If the PRO Act goes through, triple those damages, throw in a provision for the union to get their attorney's fees, sprinkle in the possibility of individual liability for the managers involved, and you have a sense of what's really at stake here with this PRO Act. Next slide. How does union organizing happen today? So I'm going to use a little example here called Bob's Grocery Store. Okay, picture like a typical grocery store, like a nice Giant or a Clemens Market or not a Redner's, that's too big. A regular grocery store, Acme. So the union may seek to organize a group of non-union employees that constitutes an appropriate unit. In a grocery store, you can have a couple of different appropriate units. You could have what's called a wall-to-wall unit, which is all hourly employees. You could have a craft unit like just the meat department because the butchers are historically recognized craft. You could maybe have a unit of just the front end, like the cashiers and the people who work at the front end of the store. You probably could not have any of those units would be considered appropriate, right? And the unit typically seeks to represent the largest unit that it thinks it can win an election in. What the union can't do today is sort of gerrymander that and say, okay, we want night employees in the meat department and first shift employees in the cashiers and in the aisles, the grocery section, they call that people whose last names end in a vowel, right? That's totally inappropriate gerrymandering. There has to be, some rationale for the grouping, and a wall-to-wall is presumptively appropriate, and a single department might be appropriate. But when you start kind of cobbling together departments that don't seem related to each other, that's where they have a problem. So to get the NLRB to conduct an election, and right now, still the only way a union can, quote, get in to a non-union business is to have the NLRB conduct an election and win that election, win a majority of votes cast in the election. To get an election, the union only needs 30% of the bargaining unit, 30% of the employees in the unit they want to represent, right? So let's say they want to represent my whole store, and say I've got 50 employees employed, full and part-time employees, excluding supervisors and managers. They would need 30% of 50, which I think is 15 employees. They could file a petition and have the NLRB conduct an election. No union in their right mind would file a petition with that little bit of support. They would want 60 or 70% support. They would want to have a majority, because they know once Bob finds out that there's actually a union organizing effort and that I'm going to have an election, I'm going to fight back and start communicating with the employees to try to convince them that unionization is not a good idea. So the scope of that unit oftentimes are worked out by the parties, by the employer and the union. So if the union were to say, we want the whole house, I probably wouldn't have much of an argument to say the whole house is an inappropriate unit. If they said, we want the meat department only, if I thought I had no chance of winning the meat department, I might say, nah, that meat department is so sufficiently integrated with the whole rest of the store, the store is the only appropriate unit. By the way, under the current standards, it doesn't have to be the most appropriate unit. It just has to be appropriate. So the labor board has said, look, this might not be the most appropriate unit, and it certainly might not be like the most convenient for the employer, but the standard is it just has to be appropriate, meaning it just cannot be inappropriate. So, if it was the front end in the meat department and none of the employees in the grocery section, that would probably be inappropriate. Anyway, those issues are oftentimes worked out by negotiation between the parties before a hearing. If you can't work them out, the NLRB will have a hearing. I have a hearing at the Labor Board in Baltimore on Thursday involving a transit services provider, where there's a fight about whether the maintenance people should be included with the drivers or not. We say they should be. The union says they shouldn't be. No surprise that we think the maintenance people probably don't want the union, and the union kind of sees the tea leaves the same way. So they're trying to keep them out because they think they can win just the drivers. And, we would rather have more, pro-company votes in that unit. So, that's been part of the labor relations landscape for 80 years since the National Labor Relations Act was passed. Currently, prior to the election, each side may campaign to win the employees' votes. And I'm sorry, I can't really see the attendees who are here. I don't know who's been through an organizing campaign. Most businesses say it's the worst thing that they've ever actually had to go through. It's much worse than like an EEOC case or, an ADA litigation or something like that. It's much more personal. It's much more visceral. It's much more us versus them, Hatfield and McCoy's. And during the campaign, which is typically, if you're the company and you only find out about it the day the union files the petition with the NLRB, at best, you're going to have 5 or 6 weeks to campaign, at best. For a while, it was like 3 or 4 weeks, which really is not enough time for you to try to turn the ship, because the union has been working on the employees for weeks, maybe months, sometimes years. Like in Amazon, we'll get to the Amazon case in Alabama in a minute. The union had years of effort into that campaign. Amazon, with its shock and awe campaign, was still able to sort of overcome all of that head start and all of that groundwork that the union had put in over a period of years. Now, the union filed objections, and that's going to hearing, I think, this week or next week. So we'll see if Amazon's win holds up on legal review. But in any case, the union can say whatever it wants in the campaign. We'll get you more money. If you don't like that supervisor, we'll get him fired. Hey, we were able to negotiate this provision with that employer up the street. We'll get them to agree to the same thing. This is industry standard. We'll get them to agree to that. You shouldn't have to pay anything for your health insurance. If we get in, we'll make the company pay the premium. They can say whatever they want. Not so for the company. Not so for the company. We can't make promises of benefits. We can't say, hey, look, if you vote no union, we will get rid of the copay on health insurance. Can't do that. It's an unfair labor practice. We can't threaten it. If you guys bring the union in, we're going to close our doors. We're going to move to Mexico. We can't say those things. We can't interrogate employees about how they or their coworkers feel about the union or how they're going to vote in the election. And we can't spy on union meetings. Those are the so-called TIPs: threaten, interrogations, promises, and spying. So during a campaign, the employer kind of has one hand tied behind its back, but at least it's still got one hand that it can campaign with. If the PRO Act gets through, both hands are going to be tied behind your back. The way like elections, right? Secret ballot election, the party which secures a majority of votes cast wins. So let's say it's a wall-to-wall unit at my store. I have 50 employees, 40 of them vote. The 20 people vote for the union, 19 people vote no union, one person votes for Donald Trump. The union wins the election, 20 to 19 to 1. And then the union represents everybody in the store. You can't avoid union representation by not voting, right? It's just like if you didn't vote in the presidential election, Joe Biden is still the president of the United States. So that then, if the union wins the election, you move to the collective bargaining phase. What about it? So the union represents all employees in the unit in which the election was just held. Typically, the union's goal is to negotiate a contract covering wages, benefits, and working conditions for employees in the unit. So at my store, let's say it's the UFCW, Local 1776. They want to, Acme's got a master agreement for most of the stores in the Delaware Valley. I've got, a store. They want to use the Acme contract as the template for my negotiations. I have no obligation to agree to that whatsoever. They can put that there and say, look, this is what everybody else is doing. What do you say? Forget about it. Stick that, where. I'm not interested in that. Bargaining starts from the status quo, right? Whatever the existing terms and conditions are is where the bargaining starts from. Parties are required to bargain in good faith. That includes making and responding to proposals, but not necessarily agreeing to any particular proposal or a contract as a whole. You ever try to buy or sell a house or a car or personal property or a business, maybe, depending, right? If you're selling, you can't force the buyer to pay a price that they're not willing to pay. And if you're buying, you can't force the seller to come down to a price that you might rather pay, than what they're offering. That's collective bargaining, right? No guarantees as to outcome. Congress and the labor board try to regulate the process by imposing this generic duty of you have to approach the process in good faith. That means you have to meet. How often? There's no set formula. It doesn't have to be every week or every month. How long are the meetings? Well, it's got to be a real meeting, couple hours, sometimes 4 or 5 hours, not like 5 minutes. They don't like bargaining by mail, although bargaining by Zoom is a thing in the COVID environment. And it's okay. It's not bad. In some ways, it's actually, I kind of like it because it's kind of easier to sort of detach and caucus with your team, and kind of be less obvious about like, oh, I wasn't expecting that, harder to read the body language. That's a two-way street too. But yeah, lots of Zoom bargaining going on around our area right now. But the key takeaways here is in collective bargaining, there are no guarantees. There are no guarantees that the employees are going to get more. They could get less. I negotiated a contract for a large industrial press maker in the Midwest 4 years ago, where there was a new owner, a young guy, who had a private equity guy who bought it from an owner who was, retiring and didn't mind losses. And my guy, who was like, 10 years younger than me, said, Bob, I don't do losses. I need give backs. I need a 10% wage reduction, and I need them to go to what our non-union employees are paying on health insurance, and I need a couple holidays and stuff taken away. Well, I didn't get 10%, but I did get the union to agree to the following collective bargaining agreement. Year one, minus 8% on wages. Year two, 0% increase. Year three, 0% increase. They're still not back to where they were in 2018 when we negotiated that contract. That's the point. In collective bargaining, it's not just, oh, I can only get more. You can lose. Employees can lose. The unions don't tell them that, but that's a fact of life. And what's also super important is to understand that neither the union nor the NLRB nor the courts can force a private sector employer to agree to a contract at all. Not like police and fire, right? Police and fire in the state of Pennsylvania, state law, they're governed by state law, not this law. State law provides that firefighters and police cannot strike in support of their bargaining demands. And the quid pro quo for that is they can't strike, but if they reach an impasse in negotiations, it'll go to binding arbitration and an arbitrator will decide the terms. That regime does not currently exist in the private sector, but it will if the PRO Act comes into play. So what leverage does the union have if the company is bargaining hard, right? And the union's not making any headway at the table. Well, they could try to put pressure on you in different ways, right? It could be a social media campaign. It could be an old school picketing campaign or a leafleting campaign, depending on your business. Could be a strike, could be an outright strike. Management has its own weapons, they call them, economic weapons. Management has the right to lock out employees, to put pressure on the employees to agree to management's demands. Strike and a lockout, sort of like the yin and yang. Congress authorized both of them. The Supreme Court has upheld the legality of lockouts. Kind of interestingly, if you kind of look at the NBA now and you're thinking like, boy, they, kind of, seem very employee oriented, and, I have my own opinions about the NBA, but wasn't too long ago, the NBA locked out the players as a means to put pressure on them to agree to the NBA's demands in contract negotiations, including a salary cap. So a lockout is a tool in the employer's toolkit for now, not if the PRO Act takes effect. So part of the narrative, from organized labor and the left behind the PRO Act, why do they need the PRO Act? They say, well, the NLRB favors employers. Totally untrue. Most of the staff at the NLRB themselves are unionized and dues-paying union members to something called the NLRB-U, National Labor Relations Board Union, okay? If you've ever been down to the NLRB office in Philadelphia, it used to be on 615 Chestnut, now it's up near City Hall. Some of the board agents who are charged with investigating charges and conducting elections have like union member flyers and pennants in their offices. They're partisan. They're openly partisan. They're supposed to be impartial arbiters and enforcers of a law, right? Don't tell me that the NLRB is in the tank for employers. There's another complaint. Well, employers intimidate and coerce employees. It's impossible for employees to form a union. They get wiped out. Employers fire employees at the first sign of union activity. Everybody cheats. Here's the reality. Employers for the last 7 or 8 years are winning more than 66% of union elections held. They're winning 2 out of 3. If you find yourself in a situation where a union has filed a representation petition with the board to represent your employees, statistically speaking, you're likely to lose. That's not to say you're going to lose if you campaign the right way and push back the right way. Delaware Valley Family Business Center member, who I will not mention, went through this about 2 years ago and beat the odds and beat the union. And they were able to do it under the legal landscape in effect at that time. Not sure they could win. Not really sure any employer could win if the PRO Act goes through. It's already illegal to fire employees for expressing union support, or coercing them, for engaging in that protected concerted activity we talked about. Another canard is that the law's enforcement provisions are too weak. There's no punitive damages. There's no compensatory damages. There's no attorney's fees in unfair labor practice cases. So unlike, say, in a Title VII EEO case, if you fire someone because of their race, which is reprehensible and no one should ever do, but let's say you messed up, or more likely, you didn't really fire them for that reason, but the jury concluded that you did, your worst day there is not just taking that person back and paying them back from the day they were terminated until the day the jury hands down the verdict, which is 2 years after you fired them. It's you have to pay compensatory damages for emotional distress. You may have to pay punitive damages, and you definitely are going to have to pay his or her attorney's fees in addition to your attorney's fees. So terminating an employee who makes $50,000 a year could be a $300,000 loss at the end of it. Doesn't work that way at the NLRB right now. There's no provision for attorney's fees. It's what's called make whole relief. If you fire someone in violation of the NLRA, your worst day is you have to take them back and make them whole for lost back pay over that time. Unions say that's not enough. That's not enough of a deterrent. PRO Act would change that. There's no mechanism to impose a collective bargaining agreement on employers that aren't willing to agree for good reason. Any number of clients I've represented in bargaining, we get to an impasse and we say, this is our last, best, and final. Take it or leave it. Oftentimes they take it. Sometimes they don't. Okay. I'm not going to impose this contract on you, but neither are you or anybody else going to impose a contract on me. That would change under the PRO Act. Bosses, individual managers, and executives currently, there's no individual liability under current labor law. That would change under the PRO Act. So here it is, the PRO Act, the impact of the potential law. Certainly, again, back to civics, American government, if Congress rewrites the law, this thing has only been amended like 4 times since 1934. It's hard. It's hard. You guys know divided government, the Senate's 50-50. It's really hard, for Congress to rewrite and substantially revise laws, particularly labor and employment laws. That would have a much more permanent, long-standing effect than the periodic ebb and flow of the cases coming out of the labor board, right? Because as the partisan composition of the labor board changes, they get confronted with a case that presents an issue that the previous board decided one way. They can say, yeah, we were wrong. We were wrong. We're going to go back the old way. A classic example of that is something called Weingarten rights. Weingarten rights refer to the notion that an employee has a right to have a coworker or a union rep sit in with him in a meeting that is reasonably likely to lead to the imposition of discipline, depending on what happens in that meeting. So I started practicing in 1998. From 1998 until like the mid 2000s, the law was non-union employees did not have Weingarten rights. Non-union employees did not have the right to say, hey, you want to interview me for something you think I did? I want to have a coworker sit in with me. And then the Clinton board in the 2000s said, we think Weingarten rights do exist for non-union employees. And all they did is the text of the law didn't change. They just interpreted it differently, which happens. So suddenly, non-union employees have Weingarten rights. Then the Bush administration came into power. I have the decades wrong, but it's the same thing. The Bush administration comes into power and says, no, we don't think that there's Weingarten rights for non-union employees. We don't think that's right. So that can go back and forth based on the partisan composition of the board. Just looking at the same issue differently and saying, we think the act means this versus we don't think the act means that. Changing the words of the act is a whole other thing. Only Congress can do that, and that's what the PRO Act would do. Now, lest I be accused of the boy who cried wolf. The PRO Act has already passed the U.S. House of Representatives. It passed last year or last term, and it went nowhere in a Senate run by Mitch McConnell. Mitch McConnell isn't running the Senate anymore. Senator Schumer is in charge of the Senate. And the Democrats have working control of the Senate with Vice President Harris breaking ties. 45 Democratic senators have signed on to this bill as co-sponsors. And about 2 weeks ago, Joe Manchin, great moderate hope, Joe Manchin said he supports it. So that's 46. So there's 4 senators out there, Warner and Kane from Virginia, Sinema from Arizona, and somebody else whose name escapes me, who are the only Democratic senators to not voice support for this bill. So how could this thing pass the Senate? I think the least likely is that they trim enough out to gain Republican support to get it over 60. That's implausible, in my opinion. A much more likely possibility and a terrifying prospect, frankly, is that the Ds vote to get rid of the filibuster, which is a Senate rule. And that in and of itself is a totally vulnerable to being modified or eliminated on a straight party line vote. If Kristen Sinema and Joe Manchin decide they want to get rid of the filibuster, it's gone. So far, Senator Manchin has said he does not support getting rid of the filibuster. But, his pronouncements on that have ebbed and flowed a little bit in their sort of forcefulness of the commitment to his position. The other way it could potentially get through is if they attach it to a budget bill and use what's called the reconciliation process, which you might recall was the vehicle they used to jam through the $1.9 trillion COVID relief bill earlier this year. That was deemed a budget bill, so it wasn't subject to the filibuster. So it was subject to just a straight, majority vote, and it passed. I think it passed 50-49. I think one of the Republican senators didn't vote. So they've got a couple ways to get this through. Handicapping it, I don't think they're gonna modify it to pick up GOP support. There's too many bad sticks in this bundle. But I'm going to go through those in a minute. I'm looking at the clocks out. But any one of these sticks would have been a heavy lift in regular times. And I just don't know. I don't know, though. I mean, I don't think they're going to try to get Republican support. I think they're just going to try to jam it through either by eliminating the filibuster or attaching it to a budget bill. So you really have to stay tuned and pay attention, to the talk around the filibuster. I think whatever the current spending blowout pending in the House, the infrastructure bill has elements of, or basically all of the PRO Act attached to it. And, as narrow as that Democrat majority is in the House, it's only like a 10-vote majority. Nancy Pelosi has those folks in line, and they will pass that bill. They will pass that bill. The PRO Act passed the House like 218 to 210, maybe a month or so ago. All Democrats behind it and 5 Republicans, including our own Brian Fitzpatrick in Bucks County. So, they could get it through. They got it through as a standalone. I think, attaching it to the big, infrastructure bill would not slow down the infrastructure bill. But I think in the Senate, the parliamentarian would say, come on, guys, it's the PRO Act. It's not a spending bill. We'll have to see. What would the PRO Act do that I'm so exercised about? First, it would override state right to work laws, which generally allow employees to opt out of dues payments to unions. No big deal in PA because we're not a right to work state. But 28 states in the country are, and that would be a big deal for them. It would allow secondary boycotts. This would permit unions to picket or otherwise coerce neutral businesses as a means to put pressure on the primary target in a labor dispute, such as the target's customers, vendors, and suppliers. So let's go back to Bob's grocery store. I lose the election 20-19. I'm furious at that guy who voted for Trump, because if he had voted for me, 2020, I win because the union did not get a majority of the votes cast. The tie goes to the employer in those circumstances. And now I got to deal with Local 1776. And I talked to a lawyer. He said, you don't have to agree to anything you don't want to. As long as you can take a strike, then the union really can't hurt you. Can you weather a strike if they take out, if they go out on a strike, how long can you sustain a strike? Well, I think I can do that. I know somebody in the staffing industry. I think I could cover with managers. However, I think I could get that done. Okay, I think I could take a strike. but I probably wouldn't be able to withstand pressure directed to my suppliers, right? So say wherever I'm buying my frozen food from, some frozen food co-op or Del Monte or whoever that might be, US Foods or Cisco, I don't know if they do supply grocery stores. I know that. Cisco supplies a lot of grocery stores in this area. If the UFCW were to put up a picket line at the Cisco warehouse supplying my stores, that's going to be a problem, because if the Cisco drivers are unionized and they honor that picket line, now none of Cisco's work is getting done. Other Cisco customers are feeling it. And Cisco's on the phone to me, Bob, what the F? You got to get this freaking picket line out of here. And the union says, Bob, we'll just sign our agreement and we'll take those picket signs down tomorrow. I can't withstand pressure put on my supplier. Under the law today, they're not allowed to do that, but they would be under the PRO Act. That's a game changer. That is a huge game changer. In 1947, in the Taft-Hartley Act amendments that the Republican Congress passed over President Truman's veto, they amended the law to prohibit what I'm talking about, secondary boycotts, because that was deemed too powerful, too harmful to business, and too much power for organized labor, and bad for interstate commerce, by the way. Part of the whole predicate for this is, and you'll see it when you hear the president and his surrogates talk about the PRO Act, they always talk about Section 1 of the National Labor Relations Act from 1934, where they say, it is the national policy of the United States to encourage collective bargaining and to take steps to strengthen unions and facilitate unionization and to encourage collective bargaining. But not just in the air. The idea was because that will help avoid strikes and lockouts and other disruptions to commerce. The whole predicate for this was, in addition to tipping the playing field and giving the working man more sway and trying to give him more leverage vis-a-vis his employer, is everybody agreed that strikes were bad and that interruptions of commerce were bad. And FDR and the Democrats then said, well, if we give employees the right to collectively bargain, they'll be less likely to resort to strikes because they'll have this more reasonable process. And as anybody who knows anything about union contracts, every union contract has an arbitration provision that provides for the arbitration of disputes, whether it's a disciplinary issue or a dispute over the meaning of the contract, which also, and that goes hand in glove with the no strike clause, right? Every union contract pretty much has a no strike clause. It says during the term of this contract, there will be no strikes or lockouts. And the parties will resolve disputes relating to this agreement by binding arbitration. Okay, that's different from contract arbitration. So this law would take us back to 1946, the year before the Taft-Hartley Act, in saying unions could put pressure on suppliers and customers and vendors as a way to put pressure on their target, which is not conducive to labor peace. That's conducive to labor pressure. And permitting intermittent strikes and slowdowns, are you kidding me? That's been outlawed for over 60 years. The idea is, look, if the union and the employees are sufficiently galvanized, in their opposition to the unions, to the employer's contract proposal, whatever the employer is doing that they don't like, to go out on strike, to put pressure on him, to make him agree to their demands, they've got to go out on strike. And the employer is given an opportunity to replace them. What employees are not allowed to do is engage in intermittent strikes. I'm striking from 10 to 1, and then I'm coming back. The employer can't replace the employee in that circumstance. Intermittent strikes are actually more disruptive to a business than a real strike, where at least, if they're going to be out, indefinitely, you can hire replacements, or you can, shut down, or you can use non-union staff to do the work. Intermittent strikes and slowdowns are viewed, for 60 years, they've been viewed as unfair tactics, and they were prohibited, but they'd be legal with the PRO Act. In the initial organizing context, the law would strangle employers' voices in union elections and abolish the employer's input in NLRB election proceedings, including regarding the scope of the unit. So getting back to Bob's grocery store, the union could just say, we want the meat department, the floral department, the seafood department, and cashiers. which is a totally gerrymandered unit. And I would have no voice to tell the NLRB that's not reasonable, right? That's not an appropriate unit. I would have to hope that the NLRB would kind of reach that conclusion themselves, because I would not be allowed to state my position on the appropriateness of the unit. That's disgusting. It would also outlaw so-called captive audience meetings, which are meetings where the employer compels employees to come and listen to him or a consultant or somebody tell management's side of the story about why unionization might not be in their best interest. Amazon used those meetings to great effect in the campaign in Bessemer. I've probably been involved in 60 or 70 union organizing campaigns over my career. Every single one, part of it is getting the employees in a room and talking to them truthfully. You can't lie. There's too easy. Everything can be looked up. You can't threaten, interrogate, promise already. Telling them lies does no good, because you get called out and then you lose your credibility. You have to maintain your credibility. But you also need to be able to tell the employees what union representation really means and how collective bargaining really works. And that just if the union gets in here, that doesn't mean you're going to get, ice cream, apple pie, and cherries on top, just because the union said so. That's not how it works. But with the PRO Act, you wouldn't be able to compel employees to come to those meetings. It would enable employees to use your email systems to communicate with each other about union-related matters, including the election. The union would decide the manner of the election, whether it be a traditional in-person election or a mail ballot election, which is what the labor board's been doing since COVID started, or email elections. It would facilitate organizing in so-called micro units, like the meat department, I think, would be an appropriate unit because that's a craft, right? That's a traditionally recognized craft. Cashiers are not a traditionally recognized craft. I'm not really sure that the labor board would certify a unit of just cashiers. But if for whatever reason the cashiers were really fired up against me and the union just wanted to represent them to get a beachhead in the store, the NLRB would say, well, just because it's too small doesn't mean it's not an appropriate unit. Home stretch, guys. How would it disempower management? Interest arbitration would be mandated if the employer and union cannot agree to a first contract. So I spent a lot of air and breath 20 minutes ago telling you how important it is that you don't have to agree to any contract that you don't want to agree to. And not only does that help you in real time, like, well, I'm not going to agree to that contract, it helps you in the campaign to tell the employees they can't make me agree to anything I don't want to. And did you know that less than half of newly organized bargaining units end up with a contract in the first 12 months? And did you know that just because they got some other company to agree to this proposal doesn't mean I have to? And did you know, there's no guarantee you're going to get a contract at all? Well, if the PRO Act takes effect, there would be a guarantee that they get a contract at all. Because if you and the union were not able to agree to a contract in something like 90 days after the commencement of negotiations, which themselves must start within 30 days of the certification of the union as the winner of the election, then the union could say, we want to go to arbitration. And then an arbitrator would be appointed, and he or she would be empowered to impose a contract upon you. That, of everything we've talked about so far, that's the first thing I think that might violate the U.S. Constitution. That might violate the Contracts Clause of the United States Constitution. I'm not sure. And you might say, well, Bob, like police and fire, they already have that. Yeah, but police and fire can't strike, right? This would give the union the best of all worlds. You can not only strike to put pressure on the employer, you can intermittently strike or engage in slowdowns. But the employer can't lock you out. That's not, what the hell, right? Like that's the absolute yin yang. They could strike, I can lock them out. Well, not under the PRO Act, you couldn't lock them out. You'd be prohibited from permanently replacing economic strikers, which itself is a huge deterrent to employees going out on strike for fear that they might lose their jobs. All of these things on here are designed, I would suggest, not just to tip the playing field substantially in favor of organized labor, but to make strikes more likely, which is the opposite of what federal labor law is supposed to do, which is to eliminate the sort of conflict that's likely to disrupt commerce. It's as almost as this, the proponents of this bill wish there were more strikes. For those of you who might have been heartened a couple of years ago by the Supreme Court decision upholding an employer's use of a mandatory arbitration provision in an employment agreement or an employee handbook with its employees that say, if you have a dispute with us, you agree that you'll submit it to binding arbitration on an individual basis, not on a class basis, not on a group basis or a collective basis, individualized arbitration. That was a huge win for employers at the Supreme Court. The PRO Act would gut that. And then winding it up, two last slides here. New wave of lawsuits. Oh, like I even as I read this, I still have trouble believing some of it. The bill would allow, that should say the bill would allow unions and employees to file suit in court where the NLRB declined to prosecute their charges. So the way it is right now, if you've ever had an unfair labor practice charge filed against you, the NLRB has exclusive jurisdiction to handle unfair labor practice charges. That means that whatever the NLRB decides goes. There is a process for review in a federal court of appeals by whichever party is aggrieved by the NLRB's resolution of the charge. And just very quickly, the way it works is Bob's grocery store, I fire the cashier because I identify her as the lead union supporter. That's illegal. She files a charge. Region 4 in Philadelphia investigates it. You know, they subpoena my phone and they get text messages between me and Sally Durstein. I'm going to fire her. Like, I'll nip this in the bud. I don't want any union getting in here. They get the smoking gun evidence that I fired the cashier because she's a union supporter. They issue a complaint. They say, okay, Bob, we've probable cause to find you violated the act. You either settle, which at the NLRB is surrender. NLRB's settlement posture is you have to give us everything we would get in trial if we were to win, which means in that case, you have to hire her back, pay her back, and post a notice for all the employees to see that you messed up and you won't do it again. If you don't want to do that, we'll issue a complaint and we'll litigate. And oh, by the way, we win 85% of the cases that we take to trial because the cases are heard by administrative law judges employed by the National Labor Relations Board. So, you know, you're playing in their sandbox, right? And then if you lose at the administrative law judge, you can appeal to the members of the National Labor Relations Board, which don't often overturn decisions by their brethren in the administrative law judge's decision. If you lose there, you can appeal to the Circuit Court of Appeals. And if you've ever taken a case to the Circuit Court of Appeals, you know you're in for six-figure legal spend right there, right? For a chance at winning. But let's say you won, right? Let's say either the NLRB said, let's say I didn't fire her because she's a union supporter. I fired her because she was late 10 days in a row. And let's say I demonstrate that I had a policy prohibiting tardiness and that I enforced it regularly against other people. And she admitted that she was late. And in any event, the time clock speaks for itself. She was always late. She was late. Regional director in Philadelphia says, yeah, I mean, the employer articulated and has proven a legitimate non-discriminatory reason for firing her. This isn't an unfair labor practice. She was fired for a legitimate business reason. Ordinarily, right now, that's the end of the story. With the PRO Act, she could take that to federal court and get a do-over. And as anyone who's had the pleasure of having an EEO case brought against you, right? It's just like that. EEO cases don't really end at the EEOC, right? The EEOC is a way station for the employee and their lawyer to get to court where they can inflict litigation costs on you and put pressure on you to settle. Those pressures don't really exist at the NLRB right now because there's no discovery, for example, there's no depositions, and there's no way the employee's attorney can get her legal fees. All of that would change with the PRO Act. So, and then last but not least, individual liability for officers and executives engaged who are found to have participated in serious unfair labor practice. So it is no exaggeration, my friends, when I say that if I, representing management for 24 years, were to brainstorm with my colleagues and to try to come up with like the most painful, potentially damaging, game-changing revisions to the law to disadvantage management and empower unions, this is what that would look like. They didn't miss anything. I can't think of anything they didn't get. So, you know, what do? First, recognize that you're covered by the NLRA today. Recognize that there's a new general counsel who is activist, who wants the NLRB to be relevant. That's sort of been a theme for Democratic members over the years. Like 20 years ago, they were grousing about, like, we're not relevant. Like, private sector union representation is under 10%. Now it's like 6%. We're not really relevant. We need to kind of beef up the non-union side of this thing. And that's why when if employers had charges filed against them, maybe for a discriminatory termination or keeping a union rep off the property or something like that, the regional offices were instructed by DC, get a copy of the employer handbook. And why is that? Because there's probably something in there that's not compliant. There might be something in there that says employees may not talk to each other about their compensation or other terms and conditions of employment. Dead bang unfair labor practice. What about conflicts of interest? The NLRB has found fault with various policies titled conflict of interest, because after all, you know, if it says something to the effect of, at all times you will refrain from engaging in conduct that could have a detrimental impact on the business, well, isn't a strike or picketing or leafleting against the company, wouldn't that have a detrimental impact on your business? The NLRB would say that's illegal. The NLRB would say that's illegal. Now, they don't know about it. There's vast non-compliance with the National Labor Relations Act simply because most employees who are not union don't really think about this law. The plaintiff's bar isn't interested because there's no attorney's fees provision in it for them. And the NLRB is a purely reactive force. Unlike OSHA, the NLRB doesn't go around knocking on doors saying, let me see your handbook. They can only respond to charges that are filed, right? But the real danger for non-union employers here, if this thing goes through, is that the plaintiff's bar is now going to be incentivized to start looking at these things. They'll have a financial interest in it. There will be more awareness for employees, and there will be more union organizing because now both hands are going to be tied behind our back. So what do we do in the face of that unhappy scenario? Reviewing existing policies and procedures for compliance to make sure that they're currently compliant. I mean, you should just be doing that as a matter of course anyway, but not just with reference to ADA and FMLA and Title VII and COBRA and, you know, the alphabet soup laws, but also this law. And lastly, training your managers and supervisors from sort of a compliance standpoint, like you do your anti-harassment training, you do your EEO training, maybe you do like DE&I training if that, you know, is something that you think is right for your business. National Labor Relations Act compliance training is right for your business to ensure two things. One, that your managers don't inadvertently engage in unlawful activity. Two, that they know how to spot signs of union organizing and be equipped to deal with it lawfully. And three, the strategic is that last bullet point, avoiding conduct that alienates employees, right? And animates employees to think, maybe I should talk to that union guy. Maybe we would be better off here with a union. The best union election is the one that's never held, right? If you want to remain union free, you want to stay off you don't want to get down that path that could take you to unionization. A union election won is a terrible victory. It's expensive, it's divisive. I like them, you know. I get paid to do those. And I used to work in politics before I became a lawyer. So I've always kind of been drawn to like the union election side of it, but no rational owner or manager or HR professional relishes a union election. So it pays to invest in a little prevention, especially on the training side, and certainly the review of your policy side, you know, to reduce your exposure to this, even if it does go through. And with that, Sally, I will shut up.
Bob, wow, we heard the passion in your voice. I really appreciate the education, the history, what to look out for, what steps to do. So thank you. And others on the call, feel free to give Bob a call. If you don't have his number, reach out to me, reach out to Bob. He's happy to answer questions. And lastly, join us next Wednesday when Andrew Grau and Steve Stagatis are going to talk about acquisitions. So thank you for joining us. Bob, thank you again today. Appreciate you.
Yes,
And,
my pleasure.
And all the best to everyone for a good day. Get outside sometime. Bye-bye.
Bye-bye.